All right, man. Well,
All right.
hopefully those last comments before we went live did not make it on air.
We are definitely going. Look at this. I've got a phone call coming in here, chiming in. How are we doing, everybody? Oh, it's John Watts and Stephen Palmieri coming to you with this weekly edition of Legal Ease. And we were just chit-chatting a little bit about TSR. Boy, is that a hot topic, huh, John?
Yeah, it's got a lot of people excited. The CFPB taking some big shots at Credit Repair Cloud, and it certainly has people thinking and talking, which is at least the thinking is good, and usually talking is good too.
Sometimes talking is what gets you sued by the CFPB, though, it seems.
That's also true.
It is an interesting time we're in, and obviously for those of you guys watching us, feel free to comment below. That is why we do this show, is for you guys. And maybe Matt Listro will even join us. I think he was chatting in there earlier. Maybe he'll grace us with his presence. But, I mean, how do we get into this mess, John? Well,
oh my goodness. I think Matt is like joining us live here.
Is he trying to plug in? So how do we get into this mess? Well, before the Credit Repair Organizations Act was passed.
Look at this. We have the legendary Matt.
Speaking of such a mess, look at this. Look who joins us. My goodness. Matt Listro, how are you, sir? See, what had happened was we had posted up that we were going live, and Matt Listro basically thread comment bombed us. And we were like, hey, Matt Listro, why don't you just come join us?
There we go.
And here he is. So welcome, Matt. How are you doing? And, we're going to probably, I guess, looks like talk about TSR. And so how do we get into this mess, John? So we were saying, so CROA was passed in 1996. But before that, the Telemarketing Sales Abuse and Prevention something Act was passed, which then enabled the Federal Trade Commission to create rules and regulations. They created the telemarketing sales rule before CROA, because they were like, these nefarious people that are promising to improve people's credit and taking their money and they can't deliver. We got to curb this in. So they did what they could to try to curb it in with telemarketing and create a telemarketing sales rule that basically, up until recently, we if there was ever a case to thank, government, we just thought you guys were kidding, because it's been around for 25 years and the FTC very rarely used it. They always used CROA when they enforced it. The problem now is you've got the CFPB was created, in 2010 or something, and they have authority under the Consumer Financial Protection Act to curb abusive practices, and they have authority under the telemarketing sales rule. They do not have authority to regulate over CROA, and the FTC still has that. So now we've got split regulators, and so now we have the CFPB. The only means that they have to get us is, their umbrella law, the Consumer Financial Protection Act, and then TSR. So they're basically just going, how shall we say, we'll say the nice way, where they're going all in, putting all their chips on the table. When FTC, every time they shut down nefarious actors, they just use CROA. So anyway, that's our background story there. So what do we have to do? And where do we start with this crazy ass conversation?
So we've got this lawsuit, and I know, and I've seen posts from Matt, and he's been doing some videos and some interviews, and we'll get to Matt in a second, because I'm interested in what he's finding out. But in the lawsuits filed against Credit Repair Cloud and the owner, Daniel, and basically saying that as a software company, that Credit Repair Cloud was helping people to violate the TSR, and that is a problem. And so it's a very serious allegation against him, with this law. And let's just summarize this TSR in practical terms. It means if you want to get paid for doing credit repair, then you show that the account was deleted, which is interesting because that's not all credit repair is. But anyway.
Well, now you sound like a conspiracy theorist. You mean you can just give general advice or assistance to help them improve their credit, like the law says, without deleting?
Yeah. So
goodness, John,
you guys show a deletion and then pull a credit report, and it's interesting the way it's worded. It's as if the credit repair company pulls the credit report, which raises issues. And
You know who the lobbyists were. You can clearly tell in 1995, right?
yeah,
When the telemarketing sales rule was penned, it was clearly not our industry lobbyists.
yeah. So basically, I fix the credit. More than 6 months goes by, pull the credit, prove it, then get paid, which is a challenge for folks that are doing credit repair. So, Matt, what are you hearing with your connections and your people? What's going on in your world? And
there has been a ton of, I have been on the phone continually since Tuesday morning when that thing got filed, with people calling up and wanting to talk about it. It's a big deal. People worried that, hey, I'm in credit repair cloud. Do you think I'm safe? Do you think they're looking at me? Should I leave? What's going on?
That's when Matt Listro takes a purely selfish stance, and he's like, "No, of course you're not safe. Go sign up for my software."
I know. No, I really truly, we said this on the webinar last night, and I really truly believe that we should come together as an industry to support Daniel Rosen, and probably what's done is done there to some degree. I mean, I don't think that leaving or staying is going to affect whether or not they look at you personally. I really don't think so. And we really do need to get behind him as an industry and support him as he goes up against the TSR, regardless of any issues you may have. Now is not the time for those issues. Now is the time to unite against this issue of TSR. But John, I posted up that I had a question I wanted to bring today, and I do. We've been posting up some questions about, we took a look at some exemptions last night on our webinar, that if the TSR says that if the consumer calls you and from a referral, that the TSR does not attach. And then so the difficulty with that is some people will interpret that and very broadly and say, hey, as long as they were referred, you're fine. And other people will say there's a provision in the TSR that says if you have a plan, a practice, or a campaign, and they would say if you have a plan of getting referrals or a campaign of getting referrals, then that TSR does attach. And also, if you're paying those referral partners, then they become sellers, and that attaches the TSR. So the question is, would a referral coming in from a loan officer, would that be exempt or not? And how do you interpret that? Is it's just a one-off referral and they're operating as your friend, so to speak, and not affiliated with your company? Are you comfortable trying to defend that? Or do you think that the CFPB would have a case in saying, well, you're getting all referrals and that's your plan or your campaign is to get referrals and therefore the TSR attaches? So we talked about that. We talked about a catalog exclusion and how that would be set up to have consumers calling in on your catalog. And also how to do it legitimately. We have a company, KredZoo, in our space who's offering services that I believe, I've looked at it pretty in-depthly and I've started with them, is compliant with TSR. And so signing up with them and using their product would be TSR compliant. My question to you, John, this is the question I wanted to bring. I want your opinion of this because I know that you've dealt in a lot of legal areas and this is pertinent to that. So I want to know, so I've recently taken steps to become more TSR compliant. You had to catch the eye roll. More TSR compliant.
We'll edit that out.
and no, that's okay. That's what it is. This is a hard issue. Everyone feels very emotionally about this. That's okay. I do too. So I'm taking steps to become TSR compliant, but I'm not 100% TSR compliant yet. I'm not. So my question is, I've heard that do the courts look more favorably? Let's say that the CFPB comes after me next week because they see this webinar, or 6 months from now or a year from now, and they come after me and say, hey, you're not TSR compliant or 100% TSR compliant. Do I get any latitude from the CFPB or from a court, from a judge or a prosecutor, because I've taken steps on my own before they came to me to start implementing some compliance steps? What's your opinion on that? And that's not just for, I bet that's just even for broad legal question, but what's your opinion on that?
Yeah, I think that, anytime somebody is under the gun, okay, we're suing a company, we're suing the credit bureaus, whatever it might be. It's always to the defendant's advantage when you can show that, let's say, here's the line of compliance. Well, it's way better to be right here than way down here. And it's better to be trending in that direction, to say, look, we're taking steps. And And I think part of it's just human nature. We see somebody that's trying to do the right thing. It's sort of hard to get worked up about that. But somebody that's just thumbing their nose at you, that's a little easier.
Have you seen that, like in the? I know you deal with a lot of debt collectors and collection companies. Let's focus on that. Have you seen that in some of your legal cases where the court or may have gone easier on a collector because they've shown that they've been taking steps to rectify the problem that they had?
Yeah, so I'll give you two examples. One is from the FDCPA, so dealing with debt collectors, and one is the FCRA, so Fair Credit Reporting Act. So with debt collectors, they have what's called the bona fide error defense. And that means, hey, we violated the law, we admit it, but we had these procedures in place to prevent this specific violation, and we enforced it. It just happened. The letters being sent to me got sent to you, Matt, and we have these careful controls in place to avoid it, but it happened. So, my debt collection was disclosed to you. Okay. In the FCRA, it really comes in when we're trying to get willfulness, because that gives us punitive damages under the Fair Credit Reporting Act. So the bureaus will come in and say, okay, yeah, we broke the law, but look, we had the wrong interpretation, but it was a reasonable wrong interpretation. We thought
they had
that
some
we were
basis.
Can we say like TSR was passed the year before the federal statute, and we just reasonably thought that congressional statute CROA superseded executive fiat? Could we use that as like just a reasonable defense right there?
I'm not sure that's going too far now, but I think that's more of a legal argument. What Matt's talking about, and I know you know this, Steve. What Matt's talking about is, hey, I'm taking steps. Like here's the bar. I'm working my way towards it, and ultimately it's going to be up to whoever has the hammer, right? The guy or gal at CFPB, the judge, the regulator. But just human nature. If you see somebody, unless you're sort of a sociopath, you see somebody trying to do the right thing. This is, can I say it this way, with TSR, those who are in the credit repair space, this is a target-rich environment for the regulators. So why go after somebody that is heading the right direction? Now, they may still do it, but you're adjusting your odds. And that's always a good thing.
This is an important point. I wasn't even thinking about that. That even if you came under scrutiny, might get you out of the scrutiny, because if you got an investigative demand, and they started to investigate you, maybe they would shift focus off of you if they saw that you were already taking steps. I didn't even think about that. I just, went to the worst case scenario that they file against you, and would the court look more favorably?
Yeah, and look, anytime, whether it's criminal, whether it's these sort of investigative things, you have to make a decision. And Credit Repair Cloud had to make a decision, I guess, last year. Do you comply? Do you fight? If you fight and win, you're a genius. If you fight and you don't win, then obviously there's second guessing going on. And, if you comply, they may go easy on you, or they may say, thank you for handing us all that information, Matt. Now we're going to, execute you. So, there are just no easy answers. And, for Credit Repair Cloud, we can all sit back and, Monday morning quarterback, hey, you should have done this, should have done that. The fact is, they're in this situation now, and they've got to figure out the best way to fight it or to resolve it.
Well, I think the interesting thing, if you look at the complaint, the main teeth the CFPB has really is not the TSR against Credit Repair Cloud, is the Consumer Financial Protection Act, which was created in 2010, which kind of says, hey, it gives the CFPB authority, and it makes it unlawful to do financial deception and things like that. And you can read the law, and they have the specific excerpt. But then they're like, and oh, by the way, then there's TSR, which we believe Credit Repair Cloud's users violated TSR. So in all fairness, I mean, they're going after a software company, and there is no statute like that's really clearly written to say software companies that provide credit repair softwares are supposed to keep their users lawful. I mean, what the CFPB is saying, well, now because of the Consumer Financial Protection Act, you're like what is it, like a larger participant or a major influencer, whatever the word is that they look for.
Mm-hmm.
Like you significant participant in like this these people breaking the law or something like that. But I mean, regardless of how you feel about Credit Repair Cloud and their marketing and everything about that, I mean, at the end of the day, it's really an interesting scenario that we're in. I mean, it's not like when they go after these credit repair companies and then the credit repair companies are like, we didn't see this coming. Well, you're a credit repair company. I mean, CROA, even under CROA, I mean, if you sneeze the wrong way, you're in violation of it. I mean, this is a software company that they're basically saying you aided and abetted, for lack of a better word, all of your users to break the law. And then you did training courses that were like, hey, all you need is a telephone and our software. So now you're promoting them to telemarket. So, I mean, in all fairness, it's definitely not like, I mean, not the kind of thing that I think Credit Repair Cloud or anybody before this thing happened last year, would have really seen coming. What do you guys think about that?
Yeah, I mean, I tell you one thing, just reading it and I follow Daniel. I've listened to his podcast, and I'm sure at some point I picked up his book, and they seem to be really fixated on the fact that he's heavily marketing this. They don't necessarily say this word, but this is a business opportunity, which traditionally regulators have been very, very strict about. So this is back in the day, you get the magazine that's got, 100 different companies you could, work from home or this franchise or that. And, it's just a lot of abuse in that sort of business opportunity space. And they seem to be saying, look, that's really what you're doing. And you just like your method is credit repair and you have the software. The flip side of that is if you have a lot of customers, why wouldn't you help them with marketing? But
I mean,
that marketing sort of coming back to, being used against him fairly or unfairly.
I mean, but the thing is, and I sort of agree to an extent with what you're saying, but like, there's really no mechanism of law that they've accused him of like deceptive advertising or whatever. I mean, like as an example, if you're a multi-level marketing company, it's required by law that you've got to give like income disclosures and things like that. Like, hey, here are triple diamonds. Here's the guy with the small island that we bought for him, but 95% of the people end up going into foreclosure. And so like they're required to give income disclosures like in their little PowerPoints or their commercials. I mean, best I can tell, yeah, he's got his plaques, and I mean, there's big companies that do that, like ClickFunnels, which is kind of like this big marketing funnel thing, which I think he probably gets a lot from them as far as marketing ideas. I mean, they've got their $1 million
club,
and everything. And I mean, I hear what you're saying, but at the end of the day, I mean, they're not going after him for like, trying to sell people business opportunities. They're saying you're a software company and you basically aided your users to violate the law, we believe, which, I mean, hey, that's what regulators do. But this is, I think this is kind of like uncharted territory is really what I'm saying. Even when they went after Lexington Law, well, okay, I mean, Lexington Law is a CRO. Mm-hmm. So we believe you violated TSR and we're going to beat you up until at some point, something happens. But this is a software company. I mean, so they've got to kind of wire the laws together, the CFPB, to kind of get whatever their agenda is, whatever that agenda is. And I mean, if they're trying to clean up the industry, I mean, what is their agenda? I don't even have an answer for that. I don't know. But
so that's a great question for Matt. If you feel comfortable speculating, what's your gut feeling on what is the purpose of this?
I do. I have a speculation on that. And I have a question for you too, John, about the legal aspect of that filing. But I think that, somebody says, why is the CFPB trying to hurt all these consumers? And, I met these guys, or at least some of the people at the CFPB. they put on their pants one leg at a time too. They're out there. I don't really think they're out to hurt consumers. I think they're out there really to help consumers, and they're trying to do the best that they can. And you know, if you look at, step back, let's go to the Lexington law case, and if you read that complaint, well, man, that's some bad advertising in there, right? And it looks like they're bad. And there's some question as to whether or not it's accurate or how much is or isn't, you know, et cetera. And the same thing with this one. If you read the complaint, some of the things sound like get rich quick. It's only going to take you 5 minutes and you're going to be a millionaire. And I think if I try and look at this logically, I don't think the CFPB is really out to hurt anybody in particular. I think that they probably did have a bunch of people. I mean, we know from the complaints they're doing business with thousands, tens of thousands of people, of small business owners, and there was probably a larger percentage of people who made complaints and said, "I've lost my money. It wasn't as easy as they said. They deceived me. I put this money in and I never even got my initial investment back because I couldn't find the customers or whatnot." And that probably led to them saying, "Hey, too many people are being taken advantage of and we need to do something." I think that the organization is really probably trying to do the best for consumers. So that's really what I think. And they used the tool that they had, because we don't like that tool. Let's be clear. We don't like the TSR, but it's a tool that they have, and it's a very effective tool because it's very effective. It's hard to not be breaking that law and wait 6 months to charge people. So that's some trouble.
It's like trying to fish in a little teeny pond with a stick of dynamite, right? I mean, it's so effective. You know, there's like no getting out of that, right? But yeah. I mean, and I hear what you're saying. That's the tools that they had. I mean, but again, you know, where is the line? I mean, again, like we'll go back to multi-level marketing. I mean, so obviously their industry has been so nefarious. They've been regulated and super regulated. They've got to give income disclosures. And of course, it is a violation of federal law, right, John? The FTC Act or UDAP laws are unfair deceptive acts and practices, which the government can enforce if you're acting deceptively. So my question is, why did the CFPB not, I mean, do they not have enforcement authority over any anti-deception federal laws? Because I know the FTC does, right? Why would they not say, you know what, you're just deceiving these poor people, and that's what we really don't like? Because there's really none of that in the lawsuit. And that's kind of what my question is.
Well,
I want to comment on that before, John, and then John, you could tell me whether I'm right. I bet it's because deception is relative, right? Whose definition of perception? And how do you define that? But the TSR is black and white. Either you are doing this or you are not. And it's a much bigger hammer for them to go after with, because it's not questionable. It's not, were they deceived? Well, I think they were. I think they were. The TSR is a factual process. And if it's not being followed, it's a violation. So I think that's the reason that it's more TSR than the other. Your thoughts?
Yeah, and look, when let's say, for example, we want to do a large number of suits, or we're going into arbitration, and this is usually called mass arbitration, you know, gather up a whole bunch of cases against the same company. It's much easier if you have something very objective. You know, imagine a debt collector that sends a letter that completely misstates the law. Well, that's easier to prove than, well, you know, each consumer who spoke to the debt collector, they were lied to. Well, now that's so individualized. So I think it is the easy thing to do. And, you know, let's be, you know, just very candid about it. There is definitely a bias against credit repair companies. And I mean, it's built into the FCRA, you know, when we're talking about direct disputes to a furnisher, you know, ignore them. You know, now people get confused and think that means CRAs can ignore, you know, but put aside that confusion. It's in there. And my memory is last summer, the CFPB, you know, kind of encouraged companies to, hey, if you think this is credit repair, you know, deem it frivolous. And, you know, we have a new administration and all that, but, you know, bureaucracy is maybe a little slower changing than, you know, who's sitting in the White House. So, I mean, there definitely is a bias there, whether, you know, people can argue justified, unjustified. And this is their tool, and to my knowledge, this is the largest software in the space, isn't it, Matt? Yeah. So
they've got just a few more clients than Matt.
It is by far.
Matt's like 20,000.
I'm really tiny compared to them. I think I'm the smallest guy out there.
Yeah,
by far.
I think
so that's fine.
Matt, you told me you had like 4 users, right? I mean, it's and 3 just quit while we've been on this.
his two buddies that had private islands with them. They've both been murdered, John McAfee and Epstein. So Matt, we need to watch out for that private island that your software bought for you, man.
It's like you kill the biggest software and you get the list of people, and it certainly has a chilling effect. I mean, look at what is going on in the space. Everybody's scrambling. Can we do the chat feature? What about the escrow feature? What about this? What about that? And so it definitely is having, I suspect, the effect that they want it to have, which, go back to what you said, Matt, we may not always agree with governmental agencies, and certainly we don't, but very few people in the world, there are some exceptions, but very few people in the world get up in the morning and say, it's a good day to be a jerk today. I'm just going to be so unfair to people. I mean, people in their own mind, they think they're doing the right thing. And so, hey, consumers are getting ripped off by, these shady credit repair places. So let's shut down the software, and I mean, a lot of the funding, I guess the credit card processing, has been taken away. And so, I think that's what they're doing. And obviously those who are in this space, and we have consumers listening, we have credit repair companies listening to this, if you're in this space, you got to be as clean as possible, and even if you say, I can't get 100%, well, I would rather be, if the IRS is coming after me, I would rather that revenue officer say, you were 95% compliant, not you were 5% compliant. I'm just going to hallucinate. That's better to be 95%. And, because you're dealing with real people. And so, I'm interested in some of the solutions being proposed. I think most people watching this know, in a way, I'm an outsider, right? I don't run a credit repair place. I have a law firm and I sue credit bureaus. And so, but I know
like the ultimate credit repair practice. If you ask me, you actually use the law to beat those bastards.
Well, we make the credit bureaus pay us, not the consumers. So,
Very nice.
But there are so many good, solid, credit repair places that are really helping people disputing legitimate things that are legitimately wrong. And to see the CFPB, at least my perception is kind of saying, well, we're going to just try to crush everybody, or at least send a message to everybody. It feels like a little bit of overkill. And one thing I want to say, Matt, you pointed out, you read the complaint, you're reading it, you're like, oh my goodness, this is horrible. There is another side to it. So, I'm normally in court, I'm on the plaintiff's side. So we make an opening statement first. Well, we don't then go immediately to jury deliberate. I wish we would, that would be nice. But the defense puts forth their opening statement. And then we put forth our evidence, and then they put forth their evidence. And then, I do closing, they do closing. And so, we do need to hear, I'm sure there's going to be a motion to dismiss filed, which will basically be saying, hey, you can't win under any circumstances, government, so kick the case out.
John, that makes me think of a question I have for you. I know I have it on good authority that, at least as of yesterday, I don't know about today, normally what happens is the CFPB will serve you with the lawsuit, and then they'll issue a press release about it. But that's not what happened here. In this case, they did the press release, and yesterday, a full day later, they still hadn't even served Danny Rosen or Credit Repair Cloud. And I have no idea if you have any experience to comment if that's at all common. Is there something afoot here? You may not even have experience in that area with these type of things, but do you have any thoughts on that?
I guess I never paid attention to that, so I don't know if it was. Well, let me say this: they're not worried about him hiding out in his basement and not answering his door. I mean, he's a very well-known guy. He's not fleeing the country or anything. So they're going to get him served. And why they did the release first, I don't know. Maybe they thought it was the right news day to do the release.
A little. What do they call that? News cycle manipulation.
Yeah, maybe so.
Right, that's right. They're like, we're not only going to sue your ass, we're going to control the news cycle as well, Daniel. But so we've got questions coming in, people chatting up and stuff. How do you comply? Let's talk about some positive things. I mean, I think at the end of the day, we don't even really know. I mean, like Matt and I, we were talking about that. There's been conflicting interpretations of what telemarketing is. Like some people had found case laws, I guess, that said like any sort of internet type thing like is considered internet telephoning. But then there's like the Kredzu guy, I think, says, well, no, there's a precedent that says it says specifically telephone, not like telephone wires or something. So
telephone versus telephone lines. It does not say telephone lines. It says telephone, and then telephone is considered voice to voice. And so are you using any communication that effectuates in a voice to voice conversation? Conversation is important. And so if you're just using a chat or an email, it's a one-way communication. It's not a voice to voice. That's the concept on that.
Yeah. So I mean, assuming that that's the concept, then okay. I mean, let's just all start e-commerce businesses. Put yourself a nice big freaking funnel up there, have the contract, and just put a big love note that says, I would love to talk to you and give you great customer service, but the feds suck. So just go ahead and commit to this contract right now. Just press hard, click, 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 boom, go to my shopping cart. Oh, now you've signed up. Now I can call you. I mean, like literally, as crazy as it is, and John and I were talking before the show started, like literally what basically the regulators are expecting us to do is the way that Credit Repair Cloud runs their business. Because if you saw Daniel's response, he was like, I don't really have a telephone. He was kind of being facetious, but I don't have salespeople. He's an e-commerce business, right? I mean, he's great at the marketing, and people get driven through the funnels and they sign up. They don't need to call up and get telemarketed, right? I mean, like literally he's doing what we need to do, but he's the one being sued and he doesn't even do credit repair. That's what I think is the irony of this whole thing. But let's say we don't have a huge e-commerce funnel set up. I mean, I guess the next best thing, Matt, there's the Kredzu concept, which is like you can chat with people, I guess. And I was asking John before the meeting, I was like, I was always kind of under the impression if you have a lead capture form, you can like have them agree before they submit, like I agree to give you permission to call me. And for me, that seems like they've kind of given you permission, like that's some sort of a contract. But John was saying, well, I don't know if that would pass the sniff test, but it would seem to me like if you're on there, hey, before you submit your information, you're giving me permission to call you, like not like submit like purchasing a contract, but just a lead capture form. I mean, that seems reasonable. That certainly seems like a reasonable defense to the regulators anyway. But I mean, again, maybe these are all just untested waters. I mean, how many precedents really are there for TSR, right? So I guess the short answer is we don't really know how to comply. I mean, honestly, and there's people out there that say the whole chat thing, that's probably the regulators aren't going to like that. You still need to wait 6 months to get paid. There's some of the folks we know that are talking TSR, and that's kind of how they feel. And use an escrow account. Well, newsflash. I mean, TSR does not say anything about escrow with respect to credit repair. It does when it comes to the debt settlement portion of TSR, because like TSR is this broad law, and then there's this little portion that deals with debt settlement, and there's other little portion that deals with credit repair. But I mean, in all fairness, TSR does not give authority for collecting money in an escrow either. So that's all theory as well. Like, well, yeah, I mean, we did collect the money from the consumer, like it left his bank account, so he doesn't have it, but it's kind of in this neutral, escrow thing. I mean, we don't know if the regulators are going to like that, because none of this stuff we have any idea. So, I mean, what are y'all's thoughts on all this?
Well, I'll say this. There's to some extent you don't know till it's been tested, and so you can wait and let somebody else test it, or you can use your best judgment right now, because if you are concerned that you're not in compliance, then you may decide, well, I'm going to do anything that hopefully gets me into compliance. I mean, but take a step back. The easiest thing is to just literally follow it, right? You wait 6 months, you pull the credit report, you send them a bill.
Josh,
and
so leave it to an attorney to go ahead and just say, like, literally just read the law. Okay, thank you, John Watts.
This session
is over, guys. Sorry to disappoint
I'm channeling Justice Scalia here. Like, just read the words on the paper.
Law says,
But I'll say this. Everybody sort of rejects that out of hand. Like, oh, you can't do that. People never pay you. I'll just tell you this. I represent a lot of people that are sued, and a lot of times, we make their lawsuit go away immediately by a debt buyer, and they may be paying me for 6 or 12 or 18 months, and I'm always amazed when they pay me. It's like I got rid of their case, and I don't threaten them or anything. They just, they pay. So I mean, if you take care of people, yeah, there are a few jerks out there, but I think the majority of people will honor what their commitment is to you. Now you have to decide, can you hold your breath for 6 months, right? To get that. The escrow thing, I think it's interesting. For whatever it's worth, I'll tell you this. We have a pretty significant portion of our practice going after what we consider to be scam debt settlement companies, typically masquerading as law firms. And they use all the escrow companies. I mean, I won't name them, but there are several very big players in the space. And I always sue them. And my thought is, you are the banker to the cartel guy. This is dirty money, and you enable it, and you're just as guilty as the cartel guy. And now they obviously disagree. Okay. But I'm just saying, there's nothing magical about an escrow account that, it may help, but the money is still going from the consumer to an account that the credit repair company has some, at least aspirations to get. Okay. So I'm not saying don't do the escrow approach. Just, be aware that nobody truly knows what the silver bullet is, other than just complying with it directly. So you've got to use your best judgment. And I would say, be very careful who you listen to. I mean, I get this all the time. People will call me and say, hey, I've got this great lawsuit against the bureaus. Here's what they did wrong. And I look at it and say, you don't have a lawsuit. Oh, yeah, I do. And let me explain to you the law, which I appreciate. I mean, I've been teaching this stuff for 20 years to lawyers, but I appreciate, this guy from New Jersey explaining to me how I've been wrong all this time. And he really knows the law. So just be careful who you're getting it from. I mean, and I don't know, Matt probably knows this. There are some lawyers that are really involved in compliance in the credit repair space. Are they chatting about this, or are they still observing things, Matt?
Yeah, Michael Thurman, Robbie Birnbaum. There's some guys in the space that this is what they do. And that's the thing, is there's just a difference of opinion. That makes it difficult. I know that I'm going to go back to for instance that I did earlier. Elvis is asking a question saying he does referrals from loan officers and realtors. And how does that affect it? Because it's the referral is from the loan officer or the realtor.
That's
and I think part of
you would think that's part of a campaign, which would be covered under TSR, huh?
Would it or would it not be? That's the question. Is it a campaign if you're not paying the realtor or the loan officer? Part of it might also be, are you picking up the phone to call that client because you were referred to them, or are they picking up the phone to reach out to you?
I don't think that matters. TSR doesn't say it has to be inbound. It's a campaign to induce a sale by use of one or more telephones on more than one phone call. So, I think it's both inbound and outbound telemarketing. And it doesn't say that a campaign, you have to pay money on your campaign. That's why it says campaign.
Yep. And then now we're dealing with the definition of what kind of plan or what kind of campaign. What's the definition of a campaign? And then now we're really getting into it, right? This is why this is so difficult. When I went to that loan company and I gave my presentation to the loan officers, did I ask them for referrals, Or did I just say, I'm here today to tell you what it is that I do so you're familiar with my services? And so it really comes down to, how are you marketing it? What are you doing when you do it? And how comfortable are you going to be to defend yourself if that becomes the case? So maybe if you could change some of your practices, and when you do your presentations, you say, hey, listen, just to be clear, I'm not asking for referrals from you. I want you to be aware of what I do. You know, because I like that referral exception. That might be one I might be comfortable in trying to defend. And I agree that there's an attorney in this space who disagrees with me. He says, hey, we think that may well be a campaign, not for the one-off, not for the guy that sends you one or two, but if you regularly get all your business through referrals and that's how you're marketing your business, then you might be harder pressed to defend that that's not a campaign. So you can see a lot of this is really subjective, and people will have different opinions.
And the
That's
other
the tough
thing,
part.
you know, Matt, you and I talked for like 30 minutes the other day, and John, we were talking before the show started, like the other word that we don't really know is the word induce, right? It says if you're a telemarketing, it's, you know, a campaign to induce a sale. Well, I mean, does induce a sale mean like I'm closing the deal right there on the phone? That seems logical versus, I mean, I'm just giving you good customer service, talking to you, and then 3 months later you send me back the signed contract. I mean, that hardly seems like any sort of predatory thing, but we don't know what induce means. And John was saying, well, it's probably clearly it's broadly construed by the regulators. So that would be interesting. I mean, because like, what is the interpretation of to induce a sale for that telemarketing? Like, if we can determine that it's very broad, if the judges have ruled, then we pretty much know, okay, well then it's a campaign, whatever that is, to very broadly generate a sale at any point in time, even if it's not on the phone. So then how do you, I mean, so we can talk, so back to the relevant questions of how do we comply? Okay, we can talk about theoretical things that really aren't allowed by law. And then we can talk about how to clearly circumvent legally TSR, right? So like escrow accounts, that's all theoretical. Okay, you wait 6 months to get paid, like actually from the client, that's what the law says, but who's going to do that? So then how do you circumvent legally TSR? Well, that would be, you don't talk to the people, honestly. You do some sort of, you build an e-commerce business, you drive traffic and you create funnels and you create, you know, like lead to the sales, you know, you get the videos and everything to where by the time they want to make the purchase and they make the purchase, you know, your e-commerce has signed them up for that, right? So, you know, then, you know, and so then the question is like maybe for John, I mean, obviously you're not a TSR expert, but like, you know, could you have like a free service that you still, I mean, it's like like if you give maybe like a free trial or something like that, like, you know, sign the contract and we're going to give you a 7-day free trial of the credit repair or whatever, you know, and so then they sign up for the free trial. They've done business with you. I mean, free trials are legitimately part of e-commerce products, and it's a sale. It goes through the sale, and then you can talk to them on the phone. Can you not? Like, I mean, these are, I think, completely uncharted territories. We don't have any answers, but why could I not have a credit repair product or a 3-day free trial, which is what the accrual right of rescission is, right? Sign up now, press hard, and you've got a 3-day free trial with your credit repair product. And after that, it's whatever, you know, $200 a month or $100 a month, or pay for deletion. And then at least that reduces the resistance of your potential client, because then they're like, oh, well, yeah, let me just go ahead and sign the e-contract right here. And it's got a 3-day trial, right? I can cancel. But now that it is a contract, they are a client. And then TSR doesn't prohibit you from actually having a telephone call with an existing client, right? So, you know, what are our thoughts on how we can tell our listeners non-theoretical ways that they could actually build business models that circumvent legally TSR? You know,
well, you know, again, I go back to, and Matt is connected to all these guys, you know, the 2 or 3 or 4 lawyers that are really prominent in this space who, you know, credit repair companies are paying them. I was speaking with somebody maybe a week and a half ago, and they had an idea, and I'm like, I can see some problems with CROA, but I'm not a compliance guy. You know, pick up the phone, call this lawyer, pay the lawyer the money, and get the advice. You know, so that's sort of the easy answer is, And if there's different views, you kind of got to pick which horse you're going to back on this. Just a couple thoughts. The whole campaign thing about referrals, and again, I'm not up on the TSR. I mean, it's not something we use in suing, but from a marketing standpoint, because I'm a student of marketing, you always talk about, well, what's your referral strategy? What's your referral campaign? How do you convince clients, former clients, other people to send you business? A campaign is sort of a systematic, well, I always do this. I always do that. I send an email every 30 days to my loan officers. I don't know. Is that a campaign? If I was CFPB, I would argue that's a campaign. Certainly if you're paying them money, I think, you get other problems besides.
If you pay them money, they could be considered a seller as an agent of your company, and that really attaches the TSR. So I think we're all pretty agreeing that if you pay them money, that's toast.
Yeah,
I think even if you don't pay them money, I just think in a very broad sense, a campaign is just a mechanism to drive traffic, like whether you pay money or not. And so if
I hear you. I'm not sure that I couldn't make sure I avoid those every monthly solicitation John was talking about. When you go into the loan officer, don't ask for referrals. When you send an email to them, you don't ask them for referrals. I think there's some possibility there if you really take the steps to make sure that you're doing it the right way. Maybe also that's not your only source of business.
It's part of your campaign, though. I mean, if you're going there to bring them cookies and donuts, I mean, the regulator is going to be, well, Matt Leistra, why did you bring cookie and donuts to these people for the last 52 weeks of the year? And oh, by the way, 100% of your business comes from them. I mean,
100% is the key. That's the key. If that's all you're doing, then maybe that's how your business is structured towards that. But if it's not 100%, and listen, there's people. Do you ever go buy a cup of coffee for your insurance agent and sit down with them? Or, things like that. So there's people that you obviously know in a business professional relationship that you sometimes get together and say, hey, I know we do business. I want to tell you about a new product that I have, just so you're aware of it. I want to keep you educated. You're not asking for referrals, you're educating. You might be able to get away with that. And I readily admit that it's subjective. And, it depends upon your documentation. What do you have? What are you doing? How are you structuring it? I get that. And it's subjective. That's where it's a little tricky.
Well, I mean, like if you think of TSR, right? So TSR, it got a Sears catalog, like in a freaking uproar. Again, keep in mind this, which by the way, there was a good question from Michelle. She was like, this thing is so old. Is it antiquated because of the new technology? Well, that doesn't matter because it is what it is. And we don't have 25 years of case law, like as technology evolved. Literally, the regulators had this thing in the garbage can for 20 years, and now they're pulling it out. So we just need to get past the fact that it's antiquated. But the Sears catalog people had a real problem when this rule came out. And so if you read the definition of telemarketing or telemarketer, there's actually a carve out in there, like an exclusion if you mail out catalogs, right? Because the Sears catalog people they were like, oh my God, I mean, if we mail out 20 million catalogs to all these American homeowners, and then we want them to call us up so they can buy the lawnmower and the Craftsman wrench. Literally, that was a campaign that induced us, that caused our phone to ring. And the recipients of those catalogs are not paying for that. It's coming into their inbox. So for that point, Matt, I would say that I don't think that your defense of, hey, I'm not paying anything to these people, because why would the Sears catalog people have to have had that excluded in a definition if that wasn't the intent? Whether hey, these people are the recipients.
I think they had good lobbyists back in the 90s.
Well, yeah, where the hell was our lobbyist? Huh? Where were we? We were busy, blowing the money as soon as we were making it in our industry. But yeah, so does it seem to be the general consensus that like chatting and things like that? The general consensus based on even the lawyers you've talked to, Matt, does that circumvent TSR?
My opinion is I believe Robbie's research. I've seen some of Robbie's research and the case law that they've done showing that the TSR is about voice communication. And there was a case that he showed me that it was the government saying that they weren't going to enforce something against an internet transaction because it wasn't a voice transaction. And that seemed to me to indicate that, okay, this chat isn't a voice transaction. It does seem the word that used in the language of the law is a telephone communication.
Yeah.
And that's not a telephone communication. It's not telephonic. There's not voice on each side. And that works. Someone was asking in the chat here is Zoom, but Zoom is a voice-to-voice-to-voice communication. If you use 2 cups and a string, that's a voice communication. If you use the voice aspect of Facebook Messenger, that's a voice communication. If you're talking back and forth, that's a voice communication.
Well, now,
that's what's triggering it.
2 cups and a string is not a telephone. Okay, that
sure is.
That is 2 cups. And
it sure is.
I saw the cartoons when I was a kid. It's a telephone.
Yeah. So.
Yeah, and just let me put something else up here. Brian Ponder mentioned, he's speaking about the same with his group tonight. And in the point of this, if you don't know who Brian Ponder is, if you're in the credit repair space, you need to, get connected with Brian. Everybody's trying to figure this out, and I would say beware of the person that has all the answers and is absolutely confident. Okay. The expression often wrong, never in doubt. If somebody's saying, oh, absolutely, you do this, this, and this, and I mean, they would just go crazy trying to get you, but they could never touch you. Really? Yeah. Let me give you an example. So the first time, it's probably been, 20 years ago, 15 years ago, I sued a defendant under the TCPA, Telephone Consumer Protection Act, for auto dial calls to a cell phone. And this was a big bank. We owed them 10 grand. They called us 100 times. And the guy said, okay, I see you sued us. You owe us 10,000. You want to pay us like 5? And I said, no, actually, I want you to pay me about $150,000. He goes, what? I said, you violated TCPA. It was intentional, $1,500 per call. And he's like, that can't be the law. There's no way that's the law. I'm like, that's the law. And so as we go through the TCPA, then we wonder, are text messages? I mean, it talks about an auto dial call. What about text messages? Universally, the courts say a text message is a call. Now, are they going to say chatting in real time is the same as being on the phone versus an email 2 hours later, an email back? I don't know. But again, I would just be careful if somebody is saying, I've got the silver bullet, I'm the only one with the answer. And just the last thing I'll say about it is it makes me skeptical when people are very mysterious and, I've got the answers and it's over here hidden behind this curtain. And,
tell me, I want to know what the answer is. I hear you. Tell me. Stop teasing me.
And look, I understand all the marketing things, you elevate yourself to the wise man, top of the hill, and, all this teasing. But this is pretty serious because people's livelihoods are at stake here. And so, again, I mean, somebody can do that and have the right answer. But it, to me, says they don't have the right answer or else they would share it freely. Okay. And, we're in an age of, knowledge is everywhere. What we're doing with this, and normally we're answering questions. We'll get to sort of normal questions here in a second, but we do that is totally free. It's not the knowledge. People are paying for somebody. They say, hey, I like what you're doing. I like your answers. I want you to help me. And I said that was final thing. This will be the final thing that I say. At least I think it will. I've been known in depositions say, I have just one more question. And then it, goes on a few more. But if you take that sort of e-commerce approach that Steve mentioned, so that's more of a lead pages, click funnels type, you bring people in and you work them through the process. It may be a 4 video series or whatever it may be. To make that work, you really need outstanding reviews. And so, I mean, you should always be getting good reviews. But if you sort of take away the ability to talk on the phone, you really need good reviews because people have to trust you. And so, find those clients that can give, not just Steven's a great guy. Well, what does that mean? It's like going on Amazon and it said, this is a fabulous product. Like that does nothing. Give me some detail. tell me about this situation. So,
One of the interesting things about TSR and like the definitions, it actually addresses the issue of upselling a client. Like it says, like if somebody's a client, but then you upsell them, that's like as if they weren't a client or something like that. Like that's covered. Well, so again, I mean, if you have a product that's already built in free trial, and then after that, like at your initial checkout, it's, you're going to have your free trial, and then it's going to convert automatically to whatever your next thing is. You haven't upsold them on anything. It's just a 2-part product that they sign up for initially. It's not like they signed up for part 1 and then you got to upsell them. When they initially checked out at your shopping cart, they checked out for the whole kit and caboodle, right? I mean, so, and again, I think this is like, we don't have any answers, but as I sit here and think about this, like how do you reduce the resistance if you literally can't talk to somebody who's not a client? I don't think, I mean, it would be hard pressed, I think, for a regulator to argue. Well, I say that it's hard pressed for them to sue a software company for violating credit repair. So, but I mean, if it's like literally sign up for the product right here, and then they put their credit card info in, they're not charged, or whatever, but they put it in, and it's a product, but it's a free product. You would think that would then allow you, to Michelle's point, hey, this law is kind of antiquated. Does it address today's technology? Well, today's technology having free trials and things like that all the time, but you are a client. Because once you're a client, then you can talk to them, right, John? It's just it's the definition of like, well, is this really if it's for free, can you consider this to be a product? Even though like for every e-commerce business, it is literally you set your product up with, do you want a free trial? But you literally do go through the purchase checkout with it. But if you can have them check out with a free trial, and then you can call them up, hey, thanks for signing up for my thing. Would you feel good maybe, defending something like that? How do you feel about the legal merits of a program like that?
I think the CFPB would say that's form over substance.
Really?
That's just a way to get around it. And I would just sort of caution everybody
you are trying to get around it. My God.
No, here, I think this needs to be the language, and this may seem silly, but I don't think we need to talk about, getting around it or circumventing it. It's just, how do we make sure it doesn't apply? I mean, because if it applies, you've got to follow it. Now, if you can figure out how it doesn't apply, now again, go back to TCPA. There was a lot of controversy over what exactly qualifies as what's called an ATDS, an automated telephone dialing system. And so companies looked at this and said, hey, we have our system. If we deactivate this one part of it, technically we don't meet that definition. And they had a lot of success with that. So now on the consumer side, that was sort of annoying to me. It's like, hey, I got this great lawsuit, and it turns out that they turned like one switch off, but they complied with the law. So if you can find a way to make yourself not subject to the TSR, then that's legitimate. But just understand that the CFPB is going to be looking for, well, this is just sort of a, you're doing something fake here with this, free trial or whatever it may be. And one thing that just occurred to me on the referral angle, if your website talks about, we get tons of referrals from loan officers, and that should tell you how reliable we are. I think that nudges you closer to the campaign, would be my view.
Yeah, we've got, Michelle was asking, hey, can we just dial it back to the basics of TSR? Maybe that makes sense. Is it okay, John, if I do a quick screen share? We can kind of pull up TSR.
Sure.
And
sure.
Let's so you can see screen share here. Can we pull this down real quick here? All right.
Matt, how many times have you looked at the TSR in the last 72 hours?
Yeah, I've been living on that thing for a while now. Yeah.
Can you guys see my screen?
Let's see. I think I can add it here.
There we go. Okay. Yeah. So basically, so it's the telemarketing sales rule, and there's a section for definitions. There's a section for deceptive telemarketing acts and abusive telemarketing acts. So on the, let's see, scope of regulations. Let's see here. So this is just enacted by the Telemarketing and Consumer Fraud and Abuse Prevention Act. Okay, so basically, So for your definitions, there's a lot of definitions, but we'll go to the important ones. So telemarketing means a plan, program, or campaign. So if you're planning to go give donuts to your loan officer, plan, program, or campaign, which is conducted to induce, that's that word, like what does induce mean? Induce the purchase of goods or services or a charitable contribution by the use of one or more telephones, and which involves more than one interstate telephone call. So that's interesting. So like they can call you and you can close the deal on the first call, and that's okay. But if they call you and then they call you again and then you call them and then you call them a few more times, that is more than one call. So you can slam them for the high pressure sale on call number one. So that's really it, guys. We just need to crack some heads. Okay, let's just slam these.
I'll say this, Stephen. Again, this is not my area. My suspicion is that's not talking about per customer. That's talking about your whole business.
Oh, well, there you go. See, that's why we have the lawyers on this show.
Now, if I'm wrong, then yeah, the high pressure, but that would seem to be against the whole spirit of the FTC.
Yeah. Okay. So yeah, I guess so. To induce the purchase of goods or services by use of one or more telephone, which involves more than one interstate call. So is that interstate call per potential client or per campaign, right? So I guess that's a good point there, John. Okay. So that's and then it says does not include the solicitation of sales through a mail catalog. So that goes back to what we're saying. So the Sears catalog.
Hey, Steve, before you move on, can we go back to that interstate telephone call for a second?
Yeah.
Because I just want to cover that for a second. There is some differing opinions, and again, this is about discussion, so let's bring up both sides. There are some people that say, hey, I only do business in my state, and therefore this is an interstate. This is not an interstate transaction. It's not state to state, and I'm TSR exempt, and that's an opinion. There's another opinion that says even if you're doing, Robbie from Kredzu, his opinion is that even if you're doing business in just your state, you're still affecting interstate transactions because that consumer is now able to apply for that Wells Fargo MasterCard or that Bank of America mortgage or what have you, and that in his opinion, would trigger the TSR because you're affecting interstate commerce. And so even in just that little bit, there's differing opinions as to how you're going to interpret that.
Yeah, there's two concepts here. If you take it literally, interstate telephone call. So that would not be affecting, that would just be, it actually is an interstate call. The problem is, let's say that you're in Connecticut. And you say, I only represent people in Connecticut. And you've got a guy in Connecticut. Well, you're from that part of the world, Matt. How easy is it to get to another state? And so you might be sitting in, I don't know, Philadelphia or New York or something.
Connecticut's really small too.
Yeah. And you pull out your cell phone and you call. Well, is that intra-state or is that interstate? I would suspect that's interstate, okay, because it's somebody calling. It's the same reason, talking about recording calls. People say, oh, well, I'm in Alabama. It's a one-party state. I can record any call, and I know I'm calling somebody in Alabama. I'm like, how do you know they're not standing in California or in Florida? Well, now it's a two-party. So the other thing is this idea of affecting interstate commerce, and this is probably what Robbie's talking about. That expression really comes from the Constitution. So Congress has the power to regulate interstate commerce. So how does Congress have the right to do all these laws that really are local in nature? Because it affects interstate commerce. And so that went up before the Supreme Court in the case, and we all learned this in law school, if I remember it, because that's been a really long time ago for me. But this person was growing wheat on the side of their yard. And that was considered affecting interstate commerce because, that might affect the price of weed. And I mean, it's there's a famous case in Birmingham, Alabama. Those who have ever passed through there was a restaurant called Ollie's Barbecue. And it's a very famous U.S. Supreme Court case having to do with racial discrimination. And does this involve interstate commerce? It's like, well, the napkins that the restaurant used came from Georgia or somewhere. See, that's interstate commerce. So it's a very broad, basically anything and everything is interstate commerce, which is why Congress can regulate so much of our lives. And that would surprise you reading the Constitution. So,
yeah, the shredded Constitution. So interestingly, real quick, because we were debating whether one phone call is for the campaign or per consumer. Down here where their upselling provisions are, it says during a single telephone call, like, means the soliciting the purchase of goods or services following an initial transaction during a single call. So, I mean, it would seem to me that if they're saying an initial transaction during a single call, it would seem to me, which involves more than one interstate telephone call, which means they're referring to if you can close them with an initial transaction during a telephone call, which means you just need to get to high pressure sales and crack these people. That's, I don't know. What do you think about that in light of comparing it to this? Do you still think this is one call for the entire campaign or per consumer, John?
I don't know. Let's see. Upselling means soliciting the purchase of goods following an initial transaction during a single telephone call. I'm not sure how that's interpreted. But, again, I come back to, it would be strange if you would sort of gain the protection of this law by, sort of hammering people into submission.
Well, hey, I mean, I'm just reading the plain English right here. You're the one who said read the plain English earlier when it got to the 6-month part. And literally right here, it says, if you can't crack them over the head and you make more than one telephone call. So, high pressure.
So I'm going to pop up from my friend Brian Ponder here. I like this LAF, learn, adapt, and follow. So I think that's a good way to look at it, because look, there's a lot of discussion, and a lot of times we can find parallel stuff. We can say, okay, well, the TSR was used in some other context. Well, what did they say about telephone calls there? I know there's some special provisions for credit repair, but, again, going back to the basics of it, you do have these words to kind of figure out, what does induce mean? Is it one phone call, more than one phone call? Is it interstate, like literally the phone crosses? Of course, it's weird now, right, with cell phones, because things are bouncing all over. It's not a landline that literally would cross a state line.
So that's your general basics of like what the definitions are. So assuming if you're a weak salesman and you can't crack them on the first call, then you're a telemarketer. Assuming that we are all telemarketers, then there's a specific section here, literally like an entire section, 310.4, abusive telemarketing acts. And there's a whole part here on credit history. Okay, again, this was passed the year before CROA. So abusive conduct generally, it is an abusive telemarketing act or practice and a violation of this rule for any seller or telemarketer. Ooh, seller or telemarketer. We need to go back and see what the definition of seller is, huh? To engage in the following conduct. Okay, so profane language. Okay, here we go. Requesting or receiving payment of any fee or consideration for goods or services represented to remove derogatory information from or improve a person's credit history, credit record, or credit rating until. Okay, this is where that 6-month thing comes from. The time frame in which the seller has represented all the goods or services will be provided. So number one is if you tell them, hey, it's going to take you 6 months, first, that time frame that you've promised them has to expire. Okay, and then the seller, which is you, the CRO, you have to provide the consumer with documentation in the form of a consumer report from a consumer reporting agency demonstrating that the promised results have been achieved, and such report having been issued more than 6 months after the results were achieved. So you literally have to figure out how to get a fresh credit report after 6 months, and then you have to demonstrate that your results were achieved, and then you can try to collect from these people. Let's see what the definition of seller. Seller means any person who, in connection with a telemarketing transaction, provides, offers to provide, or arranges for others to provide goods or services. Okay, so it still has to be in connection with a telemarketing transaction. So So there's like a whole section literally that was designed to kind of curb in this industry. And then, of course, the next year, CROA was passed. And there's also a section here for debt settlement somewhere. But, so kind of to the conversation we were having, nowhere in here does it say that you can use an escrow account. I mean, so that's all kind of theoretical. So anyway, so what do we have on here? What other questions do we have? What do you guys think, guys?
Let's see. I'm not sure who wrote this. This might have been Michelle. Just sort of going back to the basics here. And let's see. Somebody talking about sort of people being mysterious. Just pay money and I'll show you the mysterious answer to all your problems. That's right. So let's see. So there's here's one about Zoom as a form of voice communication. Yeah. So, we probably have sort of beat this thing to death in terms of, there are definitely different views out there. People are, and let me.
John, I have one for you.
Yeah.
This should be a fairly easy one. I think most people, and I'm going to ask your opinion on this, would agree, or most people have agreed, that an in-person contract signing will defeat any TSR. The TSR doesn't attach. Even if you spoke to the customer for 2 hours on the phone, but the contract is signed in person, either in the consumer's home with you, the company representative, or them coming to your office. And there's obviously a guideline if you do it at their home that will right to rescind, but coming to their office and in person, most people will acquiesce to that and say the TSR no longer attaches because it was the in-face person to person that induced the sale. No matter how good you were on the phone, they didn't sign till they were in person. So for starters, let's talk about that. Do you, as much as you can, share that same opinion that an in-person will defeat a TSR?
I'll answer it in the debt settlement context. Again, going after these, what we consider to be bogus law firms. That is the classic model. The paralegal shows up at your house or shows up at the Chick-fil-A. And, we actually use that as more evidence that this is a scam. Not, there's no protection. Now, again, we're not going under the TSR, but this is not protection. This is more evidence that this is all a scam because the paralegal is not an employee of the firm, not an independent contractor. All they are is a mobile notary. And they go there and they have their little flip chart and they, has to be sort of a physical presentation usually.
Yeah, let me be clear. I'm not claiming a notary service because we've all, or I think we've all established that a notary isn't a true representative of the business. They don't have a business representation, and that wouldn't count. I mean an actual representative of the business going out, or let's assume the customer comes into your office. There's a true representative of the business there to execute that contract with the consumer.
Yeah, the one thing I don't know about, just because, again, it hasn't been particularly relevant to me, is the sequence important? In other words, can you have a phone call, then an in-person meeting? I think if it's a real, representative, and that's where you're actually sort of, consummating the sale, then I think that that's probably good. I go back to the debt settlement scam people. They've already sold it. It's like, hey, we're going to send somebody out. They're going to, like, 5 minutes, get you signed up to this 48-page contract. So you have to look at, well, is this just, again, form over substance, or is this legit? Like, hey, Matt, I've heard great things about you. Can I come by your office and talk to you? That to me seems different than an hour-long call. All the terms are negotiated. And then you say, well, look, swing by my office. We'll sign the contract.
Let me be devil's advocate and argue the flip side of that as much as you might say we spent 2 hours on the phone, but only 5 minutes in person, maybe that face-to-face in-person meeting gave them 90% security that this was a real business and not some scam that didn't exist somewhere. So it's very hard to make it's very subjective to say what caused that consumer to make that sale. And do you want to hang your business on how that consumer would testify as to what induced them to make the sale? But because it's very subjective, I would like to think that the regulators probably wouldn't try to enforce that. That's my hope. That's my personal opinion, because it is very subjective as to, was it a conversation on the phone, or was it that they became comfortable because it was in person, there was someone physically there. This was an actual entity. I can see you, touch you, and it's not someone on the phone that we don't trust. And it's very difficult to say what percentage caused that signing. And you brought up a point, what order did it happen? I never even gave that any thought. If you meet with someone and they don't sign, but then you talk to them on the phone later and they sign later, that I wasn't even thinking about that. I hadn't even considered that.
I don't know the answer to that, but let me go back, because I may not have really given you a good answer. I think if this is a real meeting, with an actual representative, I think you're always going to have a better argument that the TSR doesn't apply. I mean, because that's sort of built into the name, right? This is, by telephone. So, and it's easier to scam somebody over the phone, and certainly it happens in person, but sort of the classic thing is, you call the older person and you say, hey, I'm with the IRS or this or Social Security, and, you scam them. And so it can be done. I'll just say it this way. It's easier to do at scale to scam people over the phone than to go door to door. Okay. And
the interesting thing, Matt, I'm sorry, go ahead.
Yeah, I was just saying, so if you are in person, and again, this is an actual representative and they come by your office, or I think that has to be better for you than, something else. And I would just make sure that in-person meeting is, it's substantive, and now it might be shorter, but it needs to have some substance to it. I mean, imagine this, the CFPB calls, the customer, well, what happened at the in-person meeting? Oh, I came in and the guy said, hey, I put little sticky notes on the 27 places to sign. I'm going to go get you a cup of coffee, be done signing by the time I come back. Well, that doesn't sound like a real in-person meeting to me.
I can testify that I personally can tell you that in-person meetings in my prior career in life are definitely more ruthless than internet purchases. I was in the car business, and God bless you, if you walked into my showroom, it was buy or effing die. And those people who are smart, Matt Leastro, I'm serious. Don't be laughing like this is some sort of joke. This is heart attack serious. The smart people, the smart way to buy a car is you reach out to the internet guy, and then you have a couple phone calls with the internet guy, and you do the freaking deal. But if you walk into my sales car lot, it is buy or die, man. My goodness gracious. So I don't think we can even say, I mean, that's what makes this whole thing crazy. And so what I was going to say, what would really be curious, Matt, is what are the case laws? Like, I would imagine there's probably some case laws that have created this theory that in-person meetings are excluded. I mean, you've been around a lot of the lawyers for a while. Is there some case law on this? Do you know?
I don't know per se, but what I will say is if you look at what's happened in our space, you look at Lexington, Daniel Rosen, it seems to be that they're really going after what we deem as true telemarketers, a consumer who's responding to an advertisement and calling in, or outbound calls, either way. But not really what we're talking about, like, you and I operating a small business, operating on referrals, meeting with people, et cetera. I want to say one of the things that I'm talking to about people these days is trying to have your set of procedures for your company. Number one, write it down and have some procedures in place that you feel you can defend. I've talked about here that some things I would feel comfortable doing and what I might feel comfortable might not be somebody else. Okay, but you've got to make a decision for yourself of what are you going to do and how are you going to defend that. So for me, I might say I'm going to take a referral because a referral is excluded from TSR. And so that might be in my company manual that we're going to accept a referral and TSR doesn't attach. So if it's a referral, then the consumer can e-sign a contract. And I might also have in my company manual that if the consumer's calling in from one of those damn lawn signs that I can't stand, sorry, pet peeve of mine, I hate when seeing that on the side of the road, we'll fix your credit. But if they're calling in from a lawn sign, if they're calling in from a tear sheet on the community bulletin board, if they're calling in because they saw you on a placemat at the diner, I've done those, they're actually pretty good. If they're calling in
saw your name carved into the urinal. That's a good place to get in.
No, that's really a good time to call.
For a good credit repair, call Matt Listro.
Yeah. But no, have that in place. If you're on the phone with a customer and they say you've got to ask every one of your customers, where did you hear about us? So now you're determining where it came from. And if you hear from them that it was the diner placemat, the yard sign, the tear sheet, whatever, that internally your company manual dictates that can't go forward until you meet with the customer. It requires a face-to-face meeting. It requires a face-to-face contract signing. Hey, before we could go forward with you, I need you to come into the office. I want you to meet us and get comfortable with us or what have you. But having some of those policies in place and starting to sort through, it's not going to say that they may catch you doing one that was a lawn sign and you did an e-contract signature for it, but maybe that's a bona fide error, because you had your company policy that we must have been confused and somehow thought he was a referral. But at least you have something to fall back on. Start to figure out how you're going to segregate this business and what you're going to do. And certainly, let's be clear, if you want to make sure you're 100% compliant and you believe that chat method is good, then go sign. I think everyone should sign up with KredZoo regardless, because they generate leads for you. And that has been pretty good because it's extra business. But it's also one vehicle that says, hey, we're starting this road, we're looking at compliance, and going back to my original statement on this call, that's showing that you're moving towards compliance. But even if you forced everybody into that channel, that certainly is the best thing, but at least trying to figure out what you could do with each channel is a good step.
Yeah. Well,
good thoughts.
If we could just figure out what the feds want, then that would be a huge step in the right direction. And if we could get Congress to change the law, that would be good too, wouldn't it? So, John, here's a question: Does the CFPB have authority to create additional rules around these existing regulations? Like, could they, and what would be involved with that process? Like, could they come in one day and say, hey, you know what? You credit repair guys, you asked for it, now you got it. Here's 600 pages of rules or something on how we interpret this TSR, which our predecessor, the FTC, just created arbitrarily from the law that Congress passed 20-something years ago. Can they come in and do that and then just completely, basically, just kill us? And say, hey, here's what it means. It means you can't do month to month, and it means that if you sniff on a telephone, then it's telemarketing, and you're pretty much screwed. What would it take for them to actually come in and create rules that are basically in binding with the enforcement of the force of law?
I've never seen them just sort of immediately create a rule. I mean, they go through a process, they get comments, they try to hear from both sides, typically have these meetings around the country.
What I'm hearing is it takes forever.
Yeah, it takes a while, So as an example, there was the idea, hey, we need to update and amend at least the communications part of the FDCPA for debt collectors. So that was a long process. And then last year they said, hey, here are the rules. They're going to go into effect November 30 of this year, 2021. But then there was an idea that it would be delayed even further. Now, that's not going to happen. So, these new rules are coming into play. But, I mean, that was a long process to get there. So, again, this is not my area of expertise. What can the FTC do, CFPB, as far as changing rules? But generally, any of these governmental agencies, it takes time. I mean, if you think about the vaccine mandate, right, for over 100 employees, that's going to be through OSHA, but that's not my understanding is they're not trying to do that through a sort of normal rule. It's like some emergency, situation. So it would be very surprising to me if the CFPB or FTC came in and said, by way of formal rule, hey, chat doesn't work. Now they might give an informal opinion, and sometimes you can, contact these agencies and say, hey, I'm thinking about doing this. Do you think that this violates the law, or do you think that this would be good? and you may just get sort of an informal opinion, but it's something, and I don't know. I mean, I suspect they're slammed with stuff right now and probably pretty tightly guarding any sort of statements by their personnel. But
well, they're on a first name basis with Matt Leistro, because I mean, he's the reason they stopped taking faxes, right? Because like you started faxing all those complaints from your software, and they were like, "Oh, forget this."
I know you're kidding, but I really think that might be true.
I'm really not kidding, actually. That's why it's so funny. So, but I mean, you actually do talk to these people sometimes, right? I mean, you've communicated with the CFPB. Have you ever been able, again, you even had them speak last year, not this year, but last year at Virtual Credit Con, which was very nice of them to come talk. And you had the FTC. I mean, are you able, I mean, like, as far, I know they said, hey, last year they were like, we'll talk about anything except for Lexington law is off the table because they were in current litigation. I can get that. But I mean, if there's ever anybody around here who has a chance of talking to these people, it's you. Is there, I mean, how's that temperature with those dialogues? And I mean, you think there's any way to have normal conversations with these people and say, hey, tell us.
I think that's part of the problem. And I'm going to take an issue there because, all right, after the Lexington case, when they were coming to speak at the convention in 2020 and 2021, it was deemed that TSR would be off the conversation table because of the pending lawsuit with Naxo, with Lexington, with pending litigation. It was off the table. Part of my issue, though, is okay. That's 2020. That's 2021. What about 2017, 2018, 2019? We had the FTC, we had the CFPB at the convention. We were talking about CROA, net impression. Never did they advise that, hey, you also need to be compliant with the TSR. I mean, it wasn't even communicated. And it wasn't off the table then. So I have some issues there that, now all of a sudden it's a big deal. And we know why it's a big deal, because that's the best. They figured out that that's a really good tool that they have. But anyway, I have some issues with that. So right now it's off the table because of pending litigation, but that hasn't always been the case. And there was really no guidance given on it. And I have some problems with that. You weren't giving guidance on it yet. Now you're expecting it to be enforced. 20 years later, I have some trouble with that.
So they basically won't even just talk at all about TSR essentially at this point. Is that kind of where you're at with them?
For the most part, yes.
Yeah.
I mean, but I'll tell you, there was a convention I was at in 2019, shortly after the Lexington case was filed. And that was really one of the big, oh my gosh, they're enforcing TSR, right? And there was a case in 2017, and so maybe it was around, but it wasn't really wasn't a big deal for that. But anyway, that 2019 really brought it to the forefront. Oh wow, they're enforcing TSR. And I heard one of their chief spokesmen at a convention get up and the old beat the chest and say, hey, we're enforcing TSR and we're continuing to do so. The audience was not a credit repair friendly audience, so it was not a credit repair friendly convention, but that was the message to the audience. And, at the time I thought maybe it was a little speaking to your audience, that they're going to, champion the consumer and stop these credit repair companies. But it turns out that they really, if you continue to look at the way things have gone, that's probably a pretty true statement.
Yeah. Well, just shut down and sell lemonade in your front yard, huh? Man, that's what the takeaway is, huh? All right.
Well, we normally we do these and we have questions from consumers, and so I don't know, Matt and Stephen, if you guys have a few more minutes, I'd like to try to run through some of these and see if we can get some answers here. So
sure.
Here's a good one. Is it true credit repair companies can't really repair your credit? So I'll let one of you guys answer that, then I'll give my views on it.
Well, it is true.
Can I grab that one, Steve?
Yeah, man, go ahead, bro.
All right. I think that's a myth I've heard a lot. Credit repairers can't really do anything, or if they fix your credit, it's only short term and it won't last. And that comes from that XB code, that XR code, XR code, that when an item gets disputed on your credit report, and this has been in existence for a long time, when something gets disputed and a creditor or the credit bureau applies the XR code to the credit report, that account, the negative aspect of that account no longer counts. And so therefore your score pops because the scoring model doesn't take into account the negative aspect of that account. Score arbitrarily goes up. At the end of the investigation, they apply the XR code, which just removes the XB code, and now the scoring model will see the negative aspect of that account. It counts, it's negative, and the score comes back down. That's where that myth has come from. It was propagated years ago because when people did credit repair, I think that code was used more widely years ago, but they saw their score initially increase as soon as they enrolled in credit repair and then come back down a month later. And that's where some of that, this is only credit repair doesn't really work. The score goes down eventually, or the items come back. And that's where that started. But credit repair, legitimate credit repair, absolutely is a great thing and can help. We look for factual reasons to get things removed. Is there a good basis to get something removed? And sometimes consumers don't even know that they have a good reason until we investigate it. And so the idea is to really examine every aspect of that account and find out if there's a reason that negative information can be removed. And yes, that's only because I've been doing credit repair for 25 years and 5 months now. There really is such a good thing as good and reputable credit repair.
Oh my goodness, Matt, I was going to take a completely different direction with that answer. I was going to say that it's true under CROA, you have to give a disclosure to the consumer that says credit repair companies cannot do anything that you can't do on your own. So, and then if you were to read like the Federal Trade Commission's website or your Attorney General's website, they're going to say that, hey, they can't do anything that you can't do on your own. And there is a disclosure that you're supposed to get signed along with the contract that, informs you of your rights as a consumer. So, I mean, technically under the Credit Repair Organizations Act, based on the disclosures we got to give you, we can't do anything that you can't do on your own. Now, that being said, I'll lean on what Matt said. I mean, obviously, if you're going to hire a professional corporation organization to work with you, they're a professional for some reason. I'm sure that they can help you. So that's where I was going to go with that one, Matt.
Yeah, the only thing I'll add to that is there is the provision under a direct dispute to a furnisher, which you can't sue under, but a direct dispute to a furnisher where they can ignore if they reasonably think it's from credit repair. That does not mean credit repair is illegal or is ineffective. And of course you can do it yourself. You can defend yourself in a capital murder case if you want to. Now, whether that's smart, and so, what I always tell people is whatever you're looking at, you're going to spend time or you're going to spend money. So if my car doesn't start because I got a dead battery, I've got to jump it or I've got to call somebody to jump it. If the transmission falls out, I got to fix it myself or get somebody to fix it. So same thing here. And I would just, if you're going to use a credit repair place, just make sure this is a reputable place and that, they explain the process to you. Okay. Again, when it's that, it's all hidden behind the door here. No, there's nothing hidden. There shouldn't be. There is no magic. Somebody says, I got the magic letter. No, you don't. There is no magic letter. The magic letter is, here are the errors. Here's what's wrong. And I want you to fix it. So let's see. We've got Scott saying a single ultra detailed dispute letter under 1681I. And that's the part dealing with credit bureaus having to investigate. For legitimate missing information, common sense errors could meet the willfulness standard. Which elements are crucial. So Scott, here's where there's a little bit of divergence in my view from what the statute would say and how courts have interpreted it. So willfulness is the same thing as recklessness or wantonness. It means like if this is negligence, this is higher than negligence. Okay. So it's not just they made a mistake, but that they maybe purposely ignored your letter. Okay. Or purposely refused to look at it. Unfortunately, a lot of courts say, well, they do have some process in place, so we're going to deem it to not be willful. And it's in the eye of the beholder. frankly. I can look at these cases over here. This is willful. Seems like same conduct over here is not willful. We certainly argue the more detailed the letter, the more specific you are, the more you lay it out in very clear language. So none of this garbage language that looks like somebody just threw a bunch of, fancy words together and it's not even, grammatically correct, but like a good common sense, understandable letter. I think it's easier for the judge to say, why didn't you guys fix this? It's pretty simple. And you can get to that willfulness standard, but there's not really a checklist. Kind of the theory is the more disputes you have on a particular account, the more likely you are to get to willfulness. We've had it on one dispute letter, and I've seen people have 5 dispute letters, and it supposedly doesn't meet the definition. So all you really can control is make your letter as detailed, as good as possible. And then if you end up suing, it's really arguing to the judge why this is willful and what you do in depositions with the bureaus. What procedures did you have? How much time did you spend? I sent you a 3-page letter with 15 pages of attachments, and you spent 37 seconds looking at it. That's better, than if they spent 3 hours and 37 minutes. So let's see here. We've got.
Jam them up with paperwork, huh?
You can't repair something that was never broken. Well, that's true. That's true. And, when we talk about credit repair, we're talking about things that are wrong, things that there are errors with, so they are broken. Now, if somebody comes to a legitimate credit repair person and everything is accurate on their report, the response should be, I'm sorry, there's nothing for me to dispute here.
I'll chime in there. The legitimate company probably won't charge them any money, which you shouldn't charge them any money, but also we can perhaps guide the consumer to do some things that they may not be thinking of, to work on their utilization, to transfer balance from one account to another, to work on utilization, perhaps to establish a new account should the situation warrant it. So credit repair, a good credit repair company isn't just doing the removal of negatives. We're also helping the consumer maximize their credit through other means, like putting positive trade lines on the credit report, adding good accounts to work on utilization, how much you owe, that type of thing. So credit repair, everyone always looks at it for the removal of negatives, but really it's more encompassing of doing everything to make the credit repair, the credit score and credit report better, not just removing those negatives.
Good point. Here's something that either Steve or Matt, I think you guys would know about this. Do you think eventually CFPB will come down on credit card processing, making it to where it will nearly be impossible to be able to do credit card processing for credit repair? What's the state of the market right now?
Well, the FTC had Operation Choke Point, 5, 6, 7, 8 years ago or something. That's what they called it, where they went into a bunch of, and they essentially choke pointed. They choked out the merchant services, and credit repair was one of them. There was a period of time where it was really rough. And so, I would only say that based on their suit against Credit Repair Cloud, which is not a credit repair company. They're a software company, but they're saying, hey, you know what? You violated these credit repair laws and the Consumer Financial Protection Act because you're like a significant participant or something like that. If they can get these precedents in their favor, I don't think there's anything to stop them from then just expanding their tentacles out and reaching to merchant service companies and saying, you guys are facilitating these people, allegedly violating the law. So if they can sue a software company, they can sue a merchant service company. That's kind of how I feel about it.
Yeah, substantial assistance. And there's a theory. There's not that many banks that deal with merchant processing for credit repair right now. There's not many banks that will engage in that service presently. And right now, some of them, they're probably not monitoring the space and knowing every day what's going on in this space and may not even have heard of that lawsuit yet. But it may spook some of the ones that are there now, right? Substantial assistance, that claim is already being made. It's being made on a software company, but it could very easily be made on a merchant company and may scare some of those banks out of this market. right now. So it may not even be, it doesn't need to have it happen later in the future that the CFPB goes after one of them. It could spook them from wanting to continue in the space right now. So it is very worrisome.
Yeah, good points. Good points. So let's see. I had my comments here, and they
I'm cherry picking right now.
no, they I tried to scroll down and it went all the way to the bottom here. Let's see. Here's an interesting one. We decline a decent amount of leads because they do not qualify as part of us running an ethical business or being overly compliant. Yeah, and look, I mean, certainly understand the frustration, and but you're always going to be better off following the law to the best of your ability, and there's always the guy or the gal that cuts corners, and things have a funny way of catching up with them. And so, it's that old cliche, it's hard to go wrong doing the right thing. And I would definitely keep trying to do that. Let's see, here's something unrelated to the CFPB. I want to file a motion for summary judgment. Is that a good idea? So probably this is in somebody who's been sued by a debt collector would be my guess. And so should you file a motion for summary judgment? And I'll answer that because I do this a lot. If you're going to file a motion of summary judgment, you have to understand the rules in your state. And so be very careful about, well, this person in Nebraska said do this, and you're in Virginia. Totally different, okay? And so you've got to understand the rules, and you have to think about, are there any unintended consequences? And here's what I mean by that. Let's say, just hypothetically, a critical part of defeating a debt buyer who sues you is showing that they don't have the actual contract where they bought the debt. So it's called the credit card purchase agreement, the pooling and servicing agreement, forward flow agreement, all different names, same thing. It's where they go out and buy, 10,000 accounts. Well, we say they have to bring that contract to court. Well, if you file a summary judgment, say they don't have it, well, can they produce it? Maybe they weren't going to produce it before. Now they are. So is that an unintended consequence? So you really have to know the rules. You have to know your opponent. You have to know the judge. And it can be a great strategy, or it can kind of blow up in your face. So just always be aware that, every move has consequences, including making no move. That has consequences as well. Here's an interesting one for you guys. I made a few critical mistakes in the dispute I mailed to the CRAs. Will sending a revised version give them a frivolous argument? He says at trial, but really we're talking about if they're going to deem it to be frivolous, they have 5 days to do that. So if they don't designate it as frivolous, they can't raise that argument later. So what do you guys think? Sending a, sort of a corrected version, saying, hey, I made a few mistakes, here's my corrected version. Does that trigger any red flags for the CRAs?
Well, I mean, if you send them additional information, then it just extends their time period from 30 to 45 days to reinvestigate. And then whenever they're done, you can always just dispute it again. So I definitely would not overthink it. I would just wait for the dispute to be done, and I would resend them whatever else you want to dispute them with.
Yeah, I would agree. And frivolous is really for a secondary dispute. This is augmenting the same dispute. And I don't know about you, but I live in the real world. And in the real world, I make mistakes. It just happens. I try not to make too many of them, but I do. And what do you do when you make a mistake? You try and fix it. So you're going to send in the correction. It's not a second dispute. It's an augmentation of the first one. And Steve is absolutely right. It gives them an additional 15 days, but they still have to respond. And it might actually confuse them a little when you've got that extra 15 days and then you're changing you're maybe depending what the change is, who knows, but it should not trigger a frivolous.
Yeah. And the other part is, and this is sort of my world thinking about litigation, I would always rather things be corrected on our end. If we send out something and we say, for example, hey, I never opened that Capital One account. And then we realize, oh, wait a minute, that was an old HSBC that got sold to Capital One. So we write to them and say, yeah, actually, that is my account. That's so much better than leaving that unsaid, because we're supposed to be the good guys. The bureaus are the bad guys. The furnishers are the bad guys. So if we make a mistake, let's acknowledge it and give correct information. Let's see. This is going back to, oh, wait, I think I put that up. That's the 2 cups and a string that Matt believes qualifies and Stephen is skeptical. It's here's an interesting one. Even think that WhatsApp wouldn't be something we could use either, since it has voice capability. That's an interesting question. I don't know. Did you say, Matt, that kind of the consensus
it depends on whether or not you're using it, because you could use voice app just to text, right? You don't have to use the voice aspect, or you could. So that may come down to usage, in my opinion. If you're going to say that the texting is okay, if you're in that camp saying texting or chatting is okay, but voice isn't, then the question is, I think, really how you're using it.
What about mental telepathy? Can we just telecommunicate?
I think that would be okay.
Well, I guess, Steve, the question I would have for you then is, are you hearing the voice in your head? Are you hearing voices, or are you just reading the text in your head? That's really the question, right?
That is, they say we think in pictures. We're all visual thinkers. And so, am I auditory or visual? That is a very good question. Maybe you can ask the CFPB for an advisory opinion on that. See what they come back with.
Hey, John, that's a question for you. Whatever happened to those damn advisory opinions? Those were great. The FTC used to do those opinion letters. They don't do them anymore, huh? What's the deal with that?
I don't know. And I suspect with this lawsuit, there's a memo that's gone out that says nobody talk about TSR.
Yeah, you can get a memo on that one, Matt Leach. Right? They're like, we're going to let case law be our memo. We're going to see what the judge says.
And the last thing I'll say about this WhatsApp thing, we had this in the TCPA context. If you have the capability, if your telephone system had the capability versus it was actually being used, and courts were split all over the place. Supreme Court finally resolved it, but the more in the idea of it's not capability, it's actually usage. And to be fair, the capability here was it could be modified. Like the argument was every cell phone is an auto dialer, and so it would qualify under TCPA. So let's see here. Here's an interesting one. A recorded Zoom. I'm not trying to reach, just genuinely concerned to verify their ID for the other service I provide. So let's kind of take a step back. What if you put videos out on Facebook, YouTube, Instagram, and people see that and respond? Well, I mean, we're sort of doing two-way communication here in a sense with people. Obviously, the three of us are doing two-way communication. But if it's just a video that's out there, people comment on it, I would think that would be very much in the kind of the texting, or chatting arena. And I would think that would be safe. Who knows what the CFPB will do.
To be clear, I would agree with that. But to be clear, they watch your video and then they sign up. Not they watch your video and then you have a phone call with them.
Right.
They watch your video. The video directs them to a page to sign up. They sign up and sign a contract, sign the contract, and then you call them. And one of the reasons that we've been successful with that KredZoo product, and one of the reasons we've been successful with that is the way KredZoo markets it, saying this is a truly compliant way. Please understand this is the way it has to be. You're dealing with compliant companies. And don't worry, if you don't like it, you'll still have a 3-day or 5 days to change your mind afterwards. And that's worked out pretty well so far.
Yeah, there's a lot of power in just being authentic and saying, here's why we're doing it, not trying to hide it. Look, there's certain rules, regulations, and, I think that's a very good approach because, there are things that we do at my law firm where people think they're going to have to pay money and they don't. And, you can sort of see in their eyes like, wait a minute, why, until we explain, well, here's why we don't charge for this. Because these companies are going to break the law and then we're going to sue them. And so we'll make more money doing that than charging you up front. And they go, oh, okay, that makes sense now. So I like that approach that you just said, Matt. Let's see. Brick and mortar sounds like the best way to do business, just like tax companies. Charges for deletions have to be good to make sense. Yeah, you definitely have to understand your pricing. And, for those that maybe are a little nervous about charging higher prices, somebody I've always enjoyed from a marketing standpoint is Dan Kennedy. And he's a direct response marketing guy. And I mean, he constantly harped on raise your prices, never compete on price. And, there's a sense in which the higher price something is, people assume it's better quality. If I say, hey, Matt, I've got a $10,000, car or a $50,000 car, you would just assume even if you know nothing about cars, you're like, well, the 50,000's got to be better. And so, pricing can be a very powerful marketing strategy. So, you've got to make sure there's profit in there for you. And, it's definitely worth studying that sort of concept of price strategy. Let's see. Somebody says need to do another live with Brian. That'd be Brian Ponder. So I think you did one on like a fifth Thursday of the month or something, Stephen. So
Yeah,
definitely a request. And let's see. Somebody's asking for Cardoza. So we don't know where Cardoza is.
he's
Probably
wall.
suing credit bureaus in California. Let's see. Okay, this is somebody, recorded videos are fine. They're not two-way communication. It does raise an interesting question. So I use something called, I just switched. It was Bomb Video. I think it's called Dub or something. But it's, you record a video and you stick
I use them. I'm there. I've been using them for about 4 years now.
Yeah, it's great,
and
so you put a little video inside of an email. Now they do have the ability to respond back by video, or they can reply back. It starts to get complicated on what is, getting to
how much time lapses between each voice communication in that aspect. Yeah. So what is it really then? Yeah. Subjectivity.
Let's see. Scott saw somebody ask a question about willfulness. Can willfulness be proven with just one really good dispute letter? Thought it takes 3 letters minimum. So there's sort of an idea out there that it has to be multiple letters. And you certainly would have better success getting to willfulness the more letters you have. So we had one case where we sued, I think, TransUnion and Bank of America, and we had like 9 or 10 disputes. Well, that's for arguing willfulness. That's better than one dispute. Okay. But I've had success with one dispute. And sometimes your client just doesn't have time to say, yeah, let's do 3 or 4 or 5 rounds of disputes here. They need to get stuff taken care of. And so it's always better to do more, if you're not in a rush. Let's see. Never brought up when they had the opportunity at CreditCon. So I think, Matt, you were talking about the regulators were there and
not commenting on the TSR enforcement. Yes.
Yeah. And look, and this is no criticism. This is just, we all get smarter, right? Maybe the next time the regulators come, you ask that question, say, is there anything that we should know about? Now who knows if you're going to get the answer if they weren't going to give it to you anyway, but
I should go back and listen to like the 2017, because I say that now, but it's been years since I listened to it. I wonder if there was anything years ago. I don't recall it, but maybe I should do a little research there just to be sure, right?
Yeah. So this just always good advice, do due diligence on, this would be true of a software provider, any type of company, before you give money in. Let's see. How do we as consumers access our open-end consumer credit plan when it comes to a vehicle? I honestly don't know, because buying a vehicle is a closed-end loan. So I'm not sure that I understand that. So do you guys know? Maybe David can follow up with us there. Let's see. Trying to dispute a charge off after every dispute letter, the credit bureaus just keep updating it. How can I get this removed? Well, the simple answer I think all three of us would give you is you have to identify errors. And if you identify those errors, you make it clear and they don't fix it, then eventually you look at suing the credit bureaus. So do you guys have any additional thoughts?
Definitely want to find the errors, but John and Matt, I have a call I've got to jump on here. So I'm going to go ahead and bow out and leave the rest of the party to you two gentlemen. And
Finally, he's gone, John. I thought he'd never leave.
When he leaves, we'll give the real answer on the TSR.
Now you see me. Now you don't.
I do. I want to chime in on that, Londa. Number one, disputing with the credit bureaus is great. We're hoping that you found an error, right? But also, I'm going to recommend writing to that furnisher. Ask them for the original contract. Do they have it? Can they produce it? Ask them for that pay history. Ask them for the history of statements. We want to do an audit of that and see if there's anything that's not right. And so the credit bureaus is one thing, but we really want to find something that's wrong. And so it's not just the people often focus on the credit bureaus and writing your letters there, but oftentimes the real argument is very often with the furnisher. And so let's go find out if they have everything. Do they calculate everything right? You wouldn't believe the amount of times that we find errors on different loan calculations from loan companies or even auto companies. I've seen that wrong. So go get some more paperwork from the original creditor and investigate and look for that error.
Yeah, some are pretty obvious. You know, you can look at your credit report and go, wow, that's just like doesn't make sense. But yeah, if you've got the time to either do it yourself or hire somebody, you know, like Matt or somebody else to kind of go some of these other routes to get the information and find the pressure point. Let's see, we have somebody saying, never seen such a thing as 100% accurate credit report. I'm going to say that that's true. You know, it's, you know, there are always errors on there.
Those credit reports are very complex. There's a lot of data there, and the chances that absolutely everything is accurate is slim. It's true.
And you know, the law is really set up for this. So we have two laws that we use under the FCRA against the credit bureaus. One is called EB, and that's what's called maximum accuracy. But the courts recognize, look, we expect them to have reasonable procedures to make this really accurate, but that's a lower standard for them. In other words, easier for them to meet than when you specifically point out errors, and that's under Section 1681I. When you point out errors, now they can zero in on that. And so they can't have this defense of, well, we get so much data and we can't look at everything. Well, I told you what to look at. And so now look at that. And the courts say now they have a greater obligation to figure out, is that information wrong? Is it right? And so, yeah, these are complex, and that's why that dispute mechanism is built in. Let's see. Somebody mentions Loom. So that's a pre-recorded, and I guess you can actually drop that in email too, can't you, Matt?
Yeah, you know, it's funny when you said BombBomb. I've been doing BombBomb since 2017. And we've just been looking at that a couple months ago. I'm going to give that up next year. I paid for it for a year because Loom is free and BombBomb is great. It's very easy and I like it. I've used it for a long time, but Loom is free. Did I say it's free? And it's free. So I've been doing it for a long time, but there are some other services out there that may not cost as much as BombBomb. I do like those guys, but free is better.
Yeah, and I'll say this, particularly for the business owners that are watching this, you know, the advantage of these emails that we're talking about is you record the video and then it runs like a little snippet, like a 2 or 3 second sort of, so there's some movement. And so when somebody's scrolling, they see this thing, they click on it, it goes right there. And it's much easier than saying, well, I'm going to record a video, put on YouTube, make it private, share the link. This is just incredibly fast to do. So it's really, really good.
The idea behind it is you hold up a little, I have these in my office, a little 12-inch by 12-inch whiteboard that you write on it. Hi, John, click play. And then I record my video, and the first couple seconds it says, "Hi, John, click play," and I put it down. But John wants to, when he gets my email and sees that picture, it says, "Hey, John, click play." Listen, 85% of the people click play because they want to know what I'm saying to them. It has their name on it.
Oh,
That's the idea
clever.
behind it. It's very effective. You got to do that. I used it to market the credit convention. If there's some of you guys are listening, we didn't do it in the past couple of years, but in 2017, 18, and 19, we had everybody. I had assistants sending out those videos. "Hey, John, click play. I want to let you know you're invited to the convention." And we did that, and just send those out.
No, that's great. That's great. So let's see. Here we go. The more uncorrected errors, missing information after a lousy investigation, does that usually equate to higher settlement amounts? So it's a very good question. There are, let me just turn this thing so it won't ring again. So there's a couple things that result in settlements. We look at your damages. So you could have economic damages, like I got a higher interest rate than I should have gotten. Maybe you lost a job, lost security clearance. We look at emotional distress damages. I think the more you dispute or the more detailed your disputes are that they ignore, obviously that's very upsetting. And that would be emotional distress damages. And then we look at the other side, which is liability. So how bad was their conduct? So we talked about how it affected me, but how bad was their conduct? And the more that you can show their conduct was bad, the more nervous they get, because it might reach that willfulness. And even if it doesn't, it's just not good for, people to find out about how sloppy these guys are. So I'll just say this, the more that you accurately dispute stuff, make it clear, common sense, and the less they fix it, the more money you generally will end up with in a lawsuit. Let's see.
John, I want to follow up on his comment there for a second. I have some experience, lots of different experience, I suppose, but I've always heard that in my state, in a real estate contract, there's precedent if you attach in the real estate contract, time is of the essence, and it triggers different meaning in real estate. If you put that wording, time is of the essence, and what he's saying, if you in your letter, could that create any more liability for the bureau or the furnisher if you included that phrasing in your letter?
I don't think it would, Matt, because they have a set period of time, 30 days basically. But a little variation on that, if you have something that's true, like, hey, I'm looking to buy a house, or I'm looking to change jobs, or I'm coming up for security clearance. And look, they ignore all that stuff. Okay. Unless they realize that you're a celebrity or, something that sort of takes you out of the normal dispute process, they don't care about that. But it's a problem for them, and it's good for you as the consumer filing suit. We're like, I told you guys. I'm like trying to buy a house. I've got 3 months before my lease expires, and you've got these errors on there, and then you just ignore it. Remember, judges are people too, and they're sitting there. It's impossible when you hear about an experience to not go inside your own mind and say, hey, has that happened to me? What would I do? You see something on the news, somebody was kidnapped, and you go, oh, wow, what if that was my wife or my child or my neighbor? You know what I mean? It's like you have to think about it. So let's see. Warren says, how long on average does an FCRA case take? So generally where I file cases, the rule is we're supposed to be going to trial within a year of the defendant answering the lawsuit. Now, COVID's kind of thrown that off a little bit. Most cases do not go to trial. So there's a lot of cases that settle in 3 to 6 months, because if you have a solid case, so we kind of talked about liability and damages. If it's really solid on liability, then they know they're going to have to pay something. And you have attorney's fees, and those are just adding up that the bureaus have to pay also, or the furnisher, whoever you sue. So a good liability case, it makes everybody think about, okay, how do we cut our losses here? So that tends to make them shorter. Let's see. When will the credit sweep plugin be available? Palmieri or Credit Admiral might be releasing their version next week. That might be somebody messing with you guys.
Trying to get us in trouble. No credit sweeps.
No credit sweeps. Let's see. That may be our last comment there. So maybe a good one to end on there. The takeaway I would say from this, Matt, is if you're in the credit repair business, you do have to do some real thinking and researching and figuring out what's your position on this TSR stuff. And so I think that's, very, very important to do. And for consumers, it comes down to, if you're going to do anything on your own, you've got to get skilled at it, or pay somebody to help you. And that would be my suggestion. And let's see here. Let's see. We've got David. Never seen such a voice. Okay, so apparently I missed something here. Okay, I think I see this. Riding public transportation, they refused me service not wearing a mask. So told me the mask rule is federally mandated. Police said it was transportation service policy. They enforced it. Let's see. So, look, this is something that obviously people have very strong emotions about on both sides. I mean, I saw an article today about these students protesting COVID restrictions. They were protesting because they wanted more restrictions, which kind of caught me by surprise. The general rule is, if you're using, let's say, a private company, you go to a business, or you get on a plane,
Uber or a Lyft. Yeah.
That's right. When I was at CreditCon, the summer, I unfortunately went late, Matt. If you remember, I had a trial and then it got settled right at the last minute. So I had to be in the overflow hotel. So I'm taking a Lyft and, that was their rule. Yep. Like, you have to agree to do it.
To wear the mask. They could do it because it's private.
Yeah.
Was that guy in a public? Was he on a public transportation? Was that the issue? Was it public there?
I think it may have been. Public transportation. So, I think that's going to be, if it's Greyhound bus. I don't know if it's
Greyhound is private, but if you're public, if you're using the city bus is supposed to be available to all citizens. I think that's what he's getting at. So if it's supposed to be available to all citizens, I guess the question is whether or not the mask mandate, is it law? Is it policy? That's tricky.
Yeah, and I can tell you, for example, in courts, we would have people saying, well, I'm not wearing a mask in court. Like, well, then you don't get to go to court, And so now if you have some, exception that's recognized, maybe a medical condition, but that's going to be something I think you've got to address with the higher ups. I mean, you can't really expect the bus driver to know that. If I'm on a plane and a friend of mine was flying recently, and the person sitting across the aisle had their mask down, and the flight attendant came by and to pull it up, and he said, I have a medical condition. She said, okay, well, I don't know, I don't know what the rules are for that, but this is certainly something that is, obviously a lot of strong feelings on both sides, and it's become political, I think, on both sides. And, I would just try to, if you're going to be in that situation, if you can, try to give somebody a heads up. If you're going to be on a plane and maybe would
you recommend carrying like a doctor's note or some kind of note from a governmental agency that you have an exclusion because of this, trying to do some legwork to get that in place?
Yeah, that might work. There's so a lot of people know about Florida. Governor DeSantis has sort of said, hey, you can't have any basically mask mandates. And so one school district said you can, but if you get a doctor's excuse. So there were these huge lines, Matt, standing outside of this chiropractor's office. And I mean, it's like a 5-minute consultation. You'd get the note, and then they changed the rules. Say, no, it has to be a medical doctor, So, it's tough on all sides. I think about flight attendants. It's like, it's not their rule. Like, they didn't make this rule, so when, and I know David wasn't doing this, but when people go crazy on the flight attendant or the waitress or something, like, that, like, take it up with the the management or the mayor or whoever it might be. Let's see here. Here's somebody: judge resigned after trying to convict me for not wearing a mask at Foot Locker, OSHA violation. So yeah, like, there's a lot of stuff here. Thank you for your generous time and expertise. You're very welcome. And let's see. Yeah. So look, we'll cut it off now, because I know I've got to file a lawsuit against a mortgage company before midnight. So I better get going on that. And Matt, thanks for being here.
Hey, thanks for having me. I appreciate you letting me come on and say hi. And thank you very much for your input on the TSR. I very much so appreciate it.
Yeah. And unless anybody think we're real organized, I sent Matt an invite about 2 minutes before this thing went live.
It was 3 minutes.
3 minutes. Yeah, none of this.
Not rehearsed at all. Yeah.
Yeah. And now everybody may be saying, yeah, that was obvious. It wasn't rehearsed, but hopefully there was some value, and appreciate all you guys,
Good times.
being here. And thanks for coming on, Matt. So we'll talk to everybody soon. All right.
Bye, guys.